Welcome everybody to another Law with Lunch talk that Partley and Plowden are putting on. Andy Sugarman and I are members of the employment team at Partley and Plowden, and we're going to be giving a talk today about age discrimination and in particular compulsory retirement policies and how age discriminatory policies may or may not be justified. We're more than a decade on since the repeal of provisions that permitted fair terminations of employment due to reaching default retirement age and the procedures that had to be followed in order to achieve that. And in that time, many employers have continued to implement or continue their pre-existing compulsory retirement policies. The impetus for this particular talk comes from the fact that Andy acted in a case recently concerning a compulsory retirement policy in operation at the Oxford University. And the EAT decision in that case of Hewitt and Pitcher to joined appeals, it came out just over a month ago. Andy's going to be talking about that case and about what that tells us in terms of the law on compulsory retirement policies. Before he does, I'm going to be giving a bit of a primer on general principles of age discrimination, particularly direct age discrimination, and focusing on the justification of policies or measures, treatment, which may be, in the first place, be found to be directly discriminatory. And at the end of the talk, we're going to give a bit of a practical checklist, which hopefully is useful. The idea being that it can be something you can turn to when you have a case come on your desk concerning perhaps compulsory retirement policies or any measures which are ostensibly directly discriminatory on grounds of age, but which the employer is seeking to justify. And that should hopefully be a helpful resource and go-to checklist. We are going to try and monitor the chat box for questions. Please put the questions in there. I can't promise I or Andy will spot them until the very end of the talk, when we'll have another look at see if there are any questions. If you want to ask any questions by just turning your microphone on, then please do, but just wait till the end of the talk. And as ever, if there's any question you don't feel comfortable asking in this session but want to ask us, you can of course just email us. All right, off we go. Andy, again, just making sure you can see the first slide, can you?
Thank you, Gareth.
Good. All right. Actually, we're going to jump straight over that one. Right. Age discrimination and direct age discrimination is like any other Section 13 claim for any other protected characteristic in principle, in that there's the two-stage test of establishing whether there was less favourable treatment, and if so, what was the reason for that treatment. One thing that I'm going to just cover briefly is the concept of the comparator for age discrimination claims and direct age discrimination claims. The Equality Act, Section 5, sets out the concept of protected characteristics in this sense for age, meaning a reference to age groups. The reference to an age group is the relevant concept for purposes of establishing a comparator in age discrimination claims, and it allows the complainant, the employee, to rather define the group as they wish, as they consider best shows the discriminatory treatment that they allege that they have suffered. For instance, a 21-year-old may allege that they are in the same age group as, say, a 40-year-old, and set themselves against or compare themselves to a group of, say, over 50. And it can be even broader or more relative than that, in simply just describing it as some people older than me. And so it's the concept of an age group and putting yourself in an age group which you then compare yourself to, rather than specifically the age of the particular employee versus a specific age of somebody else, either hypothetical or real. If, of course, the claimant establishes the necessary facts from which a tribunal would reasonably could infer that the reason for the treatment was discriminatory, and the respondent is unable to establish a non-discriminatory reason, then the claim in principle succeeds. But The difference for age discrimination is the one set out in bold there on the slide in front of you, which is that the respondent does not discriminate against the employee if it can show that the treatment of the employee was a proportionate means of achieving a legitimate aim. Now, this concept of justification comes from the Equal Treatment Directive, which allows for treatment and measures and policies implemented by employers to be directly discriminatory and nonetheless not unlawful. In order to do that, in order to justify that particular treatment, it is on the employer to establish that there was a proportionate means, that the particular treatment was a proportionate means of achieving a legitimate aim. And it's usual to take those concepts in reverse when examining whether any particular treatment is or is not justified. The first question is usually, well, what is the aim and is it legitimate? The case there referred to Selden, that concerned a partner at a law firm, and it concerned a retirement policy that obligated retirement, I think, at the age of 65 for that law firm. And the question for the purposes of direct discrimination is establishing whether or not in general the aim is legitimate, and then considering whether for that particular employer or that particular business the aim is also legitimate. The first part, the general legitimacy, is something which has been considered in a number of European Union cases and in the Supreme Court. In particular, it was considered in Selden. And what it says is that there must be, for the purposes of establishing a directly discriminatory treatment or policy or provision, there must be an aim which is wider, which goes to a social policy objective, and it is not simply something which is legitimate, which is a legitimate aim for that particular business. In Selden, the quote there on slide 4 comes from the judgment of Lady Hale, and she described it as their social policy objectives. This comes from the EU Treatment Directive, such as those related to employment policy, the labour market, or vocational training. They are of a public interest nature, which is distinguishable from purely individual reasons particular to the employer's situation, such as cost reduction or improving competitiveness. And we will know, many of us, from the Heskett decision, the recent assessment for the purpose of indirect discrimination, the reliance by employers on what's become known as costs plus reasons to justify indirectly discriminatory treatment. That would be something which might be a relevant or legitimate aim for the particular employer, but on its own would not be sufficient to establish a legitimate aim in a direct discrimination claim. In Selden, Lady Hale, in fact, gives a list of prior decisions where particular policy objectives were found to be social policy objectives, were found to be aims which were justifiable in the context of a direct discrimination claim. And Lady Hale also then in that decision goes on to break down what she considers to be the two categories into which legitimate aims for the purpose of direct discrimination will fall. We may come back to that in a moment, but in short, they're described as intergenerational fairness, category A, and dignity, category B. We don't really have time to go into detail about the sort of all of the legitimate aims which might fall under either of those categories, but just very briefly, category B is an interesting one. Category B is something which in Selden, Lady Hale considered to be something of she had doubts about that particular category as being something which would withstand, I think, the long-term trajectory of age discrimination. It's something which, now that the EU directive does not, now post-Brexit, now the EU law does not apply as it did in the past, and that the Supreme Court may diverge from it, it may be something which is a category which does not provide a ground for employers to rely upon in the future. But that is the sort of summary of the social policy objectives which are required in order to establish a legitimate aim within direct discrimination. The cases there, West Yorkshire and Homer and Heskin, which I've mentioned, they are cases concerning indirect discrimination. West Yorkshire and Homer concerned a detective, and it was about the need for a law degree. He was at the time, I think, 62. It would have taken him several years to complete the law degree in order to move up the higher career structure. At the he at the time was no longer directly with the police. He was with an organization that provided legal advice to the police. And his argument was, well, by the time I reach, if I were to complete a law degree, by the time I do that, I'll have reached retirement age anyway. That was an indirect discrimination case, but it's a useful case for anybody who has this type of issue arise in their own cases, to go back to and compare with the Selden case, for instance, to understand the differences in approach that the courts will look at when they're considering what is a legitimate aim for the purposes of a direct discrimination claim and what's a legitimate aim for the purposes of an indirect discrimination claim. So if one is able to establish that there is a legitimate aim which is being pursued for the purposes of a direct discrimination claim, the respondent then has to go on and establish that the actual treatment was a proportionate means of achieving that aim. And there's two things I would say about the slide that's up right now. The first is that it's the policy that is the focus, or the measure which is then applied to the particular employee, that should be the focus. Again, in Selden, Lady Hale considers this particular point, and it considers that it's the policy itself that needs justifying, not necessarily the subsequent application of that policy to the employee. Andy may come back to this issue when he deals with the implications from Hewitt and Pitcher, because of course in that case it was the same retirement policy that was the focus of the two decisions, and there were two different decisions reached. So he may come back to that. The second thing I would raise is I'll just say I've got a note to say. Andy, can you still hear me?
I can hear you, Gareth, yes, but okay, Sarah's put a
yeah.
comment on, hasn't she? She's lost sound. I wonder if anyone else is having difficulties hearing, perhaps they could put it in the chat.
Okay, I think it may just be you, Sarah. We'll carry on. Sarah, if you're able to join back in and let us know in the chat box if you can hear us. Andy, I'll let you monitor that. So that's the first thing I want to say about the slide. The second thing is the question of, well, who determines if the particular measure or treatment is an appropriate and reasonably necessary one? The answer is it's for the tribunal in the first place. It's not for the employer to determine what is appropriate and reasonably necessary to achieve the particular aim being pursued. That's for the employment tribunal. The decision at the Court of Appeal, there's a few cases arising out of this case of Harley, Hansons and Lax. There's an EAT decision, but there's a Court of Appeal decision which specifically addresses this concept and establishes that it's an ex post facto assessment. The tribunal is looking back at the situation and is establishing whether or not the particular aim is one which can be justified because on the basis that it is proportionate. And it's for the tribunal to scrutinize that and determine whether or not that's been established, not for the employer to determine. It is expressly not a range of reasonable responses question, and it is not for the employer to say, well, we may have thought that perhaps a lesser measure would have achieved the same aim, or we would have thought that on these particular facts, a different decision could have been made given the particular case. But we're not going to interfere with it because the employer has established that it fell within the range of reasonable responses that an employer might take. That's not the right way to look at whether or not a legitimate aim can be justified as being proportionate, or whether treatment can be justified as being proportionate. It's for the tribunal to critically evaluate that and determine it itself. And the reason, I think I would say there's two things on this. I think the reason, the third thing I would say is the reason for the approach that the employment tribunal is taking about whether or not is required to take about whether or not the particular treatment is justified in direct discrimination cases is that what is happening here is a balancing act between the by this point of the test, an accepted discriminatory level of treatment versus a legitimate aim which has already been established. So the tribunal is having to say, well, where should the balance be struck in seeking to derogate only from the principle of non-discriminatory treatment to the least extent that can be justified, to the least extent that might be proportionate in the circumstances. So you've got an established discriminatory act, you've got an established legitimate aim to be pursued, and it's about balancing those two competing aspects. And that's why the obligations falls on the employment tribunal to undertake that exercise. Well, what does proportionate mean? It means appropriate and reasonably necessary. Appropriate is a concept which has in other ways been described as whether or not there is a rational connection between the measure and the desired outcome or aim. Does the actual measure achieve or help to achieve the aim that is being pursued? If it doesn't, if on proper scrutiny of the evidence and perhaps statistical evidence, it can't be shown that the actual policy in place achieves the thing you're trying to achieve, then there's no rational connection to it. It's not an appropriate measure to achieve that aim, and it will fail on that basis, and the justification defense will fail on that basis. This is the area that probably requires most of the focus in terms of the concrete evidence, if I can put it that way, when it comes to making out a justification defense at a tribunal. And it's an element that requires a careful assessment of the evidence and when advising clients before you ever get to the point of establishing a defense at a tribunal, how it's going to be pleaded, what evidence there might be in support of a particular justification defense. This is where the focus would be in terms of the review with the client of what evidence there is to support it. I'm just going to jump over the third reference there about whether it contains exceptions. I think Andy may touch upon this in his part of his talk, but the reason that's raised is it can be relevant to consider, well, are there any exceptions to the policy that is being attacked? And do the extent of those derogations or exceptions undermine the policy to such a degree that it in fact harms its intended aim? So it harms its ability to in fact be rationally connected to the aim being sought. If it does, that will lessen its effect, that will lessen its importance, and it will lessen the impact that it can have, and that will harm again the justification defense. Necessary, what does that mean? It means reasonably necessary. Various domestic cases and European cases have considered the word necessary and added the prefix of reasonably. Again, reasonably necessary just simply considers whether there are less discriminatory ways of achieving the same aim. The test is not whether or not there were lesser means of achieving the aim, and if there were, therefore it's not reasonably necessary. Again, going back to the Hardy and Hanson's case, the judgment there describes the test as being whether or not the respondent can show that the measure is justified objectively, notwithstanding its discriminatory effect. So the added prefix of reasonably allows for the fact that there may be, although it not being a range of reasonable responses test, there may be perhaps shown another way to achieve the aim sought. It may be argued that that has a lesser discriminatory effect, but simply because there might be something which could have been done which might be of a lesser effect will not in and of itself render the justification defense would not be fatal to the justification defense. So it's not is anything lesser capable of being done to achieve the aim, but it's whether or not it can be justified objectively despite its discriminatory effect. The burden of all of these aspects, so establishing the legitimate aims, both in terms of the policy objectives, the particular aims for the purposes of the employer, whether or not it's an appropriate means, i.e. it in fact is rationally connected and achieves it, and whether or not it's reasonably necessary, all of that falls on the respondents. Can the employer produce evidence that supports its case that the discriminatory treatment should be justified? There's a case there referenced on that slide of Cockram. Again, I think Andy might cover it, but just briefly in case he doesn't in any great detail, it's a case about an employee who worked for a company that had a long-term incentive plan, and the policy provided that if you left before the age of 55, you lost all of the unvested awards under the LTIP plan. But if you left, there was a retirement exception that if you left after 55, you would keep unvested elements of the long-term incentive plan, even though they hadn't vested, if provided you'd reached the age of 55. And it was accepted this was direct discriminatory. In the respondent's case was that it was justified because there was a legitimate aim being pursued, which was to incentivize retention of employees to at least the age of 55. In this case, Mr. Cockram left at 50. It was in part due to, from what I gather from the case, due to a defined benefit scheme pension he was on at the time, and he was able to retire at 50. But his case was that it was directly discriminatory. Now, the reason it's of relevance for our purposes here is it goes to the question of, well, what evidence is the respondent able to produce to support its case that a particular measure should be justified, i.e. it was reasonably necessary. And it was challenged on appeal that there was no evidence brought to bear by the respondent, by the company in that case, to show that support or to support that this aim in fact was necessary, or that it achieved it was being achieved by the retirement exception, i.e. the fact that if you stayed beyond 55, you would keep your invested elements under the LTIP plan. Whether or not that in fact was producing that result, were people staying beyond 55? The appeal court were content to accept that that would be something that was so obvious that it would not really require evidence at all. It was an obvious concept which any employment tribunal could accept as likely to achieve that aim. And it wasn't necessary for the company to then show via statistics, via its the employees that stayed beyond 55, let's say, that in fact it was achieving that aim. So Cockram is relevant as a decision for these particular purposes in that it talks about, well, what evidence is going to be needed to establish on the respondent's part all of the things: the legitimate aim, the fact that it's an appropriate means, and the fact that it's reasonably necessary. Again, just going back to the idea, this is a balancing exercise that really, that's what the tribunal is conducting, and it requires an assessment of both the qualitative and the quantitative effect. So how seriously, excuse me, does the treatment impact upon people, and how many people are affected? With retirement policies, it's probably more about the seriousness of the impact, the qualitative impact, but depending on the measure or depending on the particular provision, both of those aspects are key factors that the tribunal will want to look at to determine how discriminatory is the treatment that's being sought to be justified. So just before I turn to Andy, that sets up hopefully the background of justification of direct discrimination, and when one is compelled to retire under a policy, therefore a dismissal is taking place. Leaving aside whether or not the unfair dismissal claim could succeed, there is inevitably going to be a direct discrimination claim on grounds of age coming if the employee believes that the retirement policy cannot be justified, and it's for the employer to justify it. That should take us to the Ewart case. Andy, over to you.
Thank you very much, Gareth. I shall assume everyone can hear me until you tell me otherwise in the chat box. Lovely to see so many familiar names on the attendee list, even if I can't see your faces. Hopefully we'll be able to have face-to-face talks in the near future in our new chambers, which will be ready soon. I'm going to talk about Ewart and Pitcher in some detail, not because it's interesting to me, although it is, but because I think it's helpful for other cases in which compulsory retirement schemes are being considered. The principles and the points of law which were relevant in that case have, I think, wider application. The judgment, as Gareth said, came out of the EAT came out about a month ago, although, and therefore it's probably new to most of you, as is often the way, it's certainly not new to me or Professor Ewart, who really neither of us seem to be able to remember a time when we weren't dealing with this case. It's been going on that long. Professor Ewart was a professor in the atomic and laser physics department at Oxford. He was a world leader in his field. He was an associate professor, which is the second most senior position, one below statutory professor, of which there are a small number. And despite several conferences with him, where he explained to me his what exactly he did, I couldn't possibly relay it to you now, because it was far too complicated. But luckily for you and for me, you don't need to know to understand the case. Oxford, as Gareth said, in 2011, compulsory retirement policies had to be justified. Otherwise, they were found to be directly discriminatory. The exceptions to them were removed. And Oxford, along with Cambridge, were the only two universities who decided to retain compulsory retirement policies. All the other universities, including the Russell Group, decided to dispense with them. Just as an aside, really, the person responsible for, or one of the key figures responsible for the Cambridge scheme was the person who taught me employment law, and who is in large part responsible for me being an employment lawyer. And last time I saw her, she told me that if I won the Ewart case, she wouldn't speak to me again. So I'm hoping that was in jest, but we'll find out next time I see her. But Cambridge and Oxford were one of the only two universities who retained the scheme, along with a small number of other employers. I say a small number, a small percentage really. That Evershed survey referred to on that slide was from 2013, and I haven't seen a more up-to-date figure. But 2.9% of all employers is, of course, still a lot of employers who, in raw numbers, who are still retaining, or were at least then retaining such schemes. Now, as a tribute to Chris Whitty, I think I'll say next slide, please. Thank you. Oxford had a number of aims, as many employers do, in having such a scheme. And the aims they relied upon were not particularly unusual, so I would imagine would be applicable in other similar cases, and you can see them set out on the slide. The key ones perhaps were promoting intergenerational fairness. That means doing or being fair to the younger generation, creating, often it's understood as, opportunities for career progression. Interesting feature of this case was that actually the evidence was Oxford didn't really recruit for the senior positions internally. This wasn't about promotion for junior academics, because they recruited really from a world market. They were often getting people in from abroad. And so intergenerational fairness is not necessarily, and the tribunal accepted this, is not necessarily being fair to one's own employees, but being fair to the generation generally, no matter where they're based, which was not a point I'd seen raised previously. Refreshing the academic workforce was an interesting one, because at times that looked like refreshing as in out with the old, in with the new, which wouldn't sound particularly like a legitimate aim, more like unjustified discrimination. But in fact, it was argued more sensibly on the basis of it being the refreshment of ideas, which was key for an academic institution. And that was accepted as a legitimate aim. Succession planning, which is really two things: knowing when vacancies will arise, that's an administrative point, and creating internal promotion opportunities, so allowing those who are already employed to progress, slightly different to intergenerational fairness. And you can see it's in red on this slide, as is the bottom one, because those aims were not found to be legitimate aims adopted at least by Oxford, because, as I said earlier, they were recruiting from a different marketplace largely. And then the key one, perhaps, promoting equality and diversity. That's on the basis that, particularly amongst Oxford academics, although I suspect you could say the same about many professions, the older generation tends to be less diverse than the younger generation. And if we are to progress towards equality more quickly, then it's necessary that the younger generation has a chance to be recruited and progress. The last one was not found to be a legitimate aim because, for the reasons that Gareth already said, it needs to be a social policy aim, and that wasn't a social policy aim. So this case was not really about legitimate aims, it was about proportionality and whether the aims which were found to be legitimate, all those in black, were justified. Next slide, please, Gareth. Thank you. So the compulsory retirement policy at Oxford, the EJRA, the employer justified retirement age, as it liked to call it rather presumptively, was slightly unusually one which the employees to whom it was applied had a vote on it, because it was put to the congregation, which consisted of the academics. And so they had a chance, if they didn't like it, to raise objections and have a vote on it. And they didn't do so, largely because I think it bypassed most of them. But that was obviously a factor in favour of the policy being justified, and not one that applies in other cases, because mostly employees don't get to choose the policies that the employer applies to them. But nevertheless, that didn't save it, which it may be helpful to other challenges. This was a policy which changed over time, and it's now undergoing a further change during a 10-year review. And so there were different iterations of the policy at different times, and the aims were slightly modified over time and reworded, but largely remained as I've outlined on the last slide. And then, as with some of these schemes, although not all, it was not a blanket policy. It permitted exceptions, and so academics could apply. I say academics, it also applied to non-academic staff originally, although its scope was narrowed. Academics could apply to stay on, and certain criteria were applied to them. And the criteria were quite complex, but I've tried to summarize them here. But essentially, the overriding point was there needed to be a sufficiently clear advantage to the university in having the academics stay on. So it weighed the advantages to the university against the opportunities arising from a vacancy. And we said that that was the wrong balancing exercise to be carrying out. Really, you ought to be weighing, as Gareth said, the discriminatory impact against the legitimate aims of the policy, and that applied to an extension procedure as much as it did to the policy itself because it was being considered in the round. The extension policy was used very liberally to start with, and lots of academics were successful under it. And so over time, it was tightened up very significantly, so that by the time Professor Ewart made his second application, barely anyone was getting an extension. And the reason for that was because they were worried, or they said they were worried, that a liberally applied extension policy might undermine the aims which was being or sought to be achieved. And I'll talk a little about that in a moment. So that was the policy in a nutshell. I haven't said what age it applied to, but it was to essentially to age 67 at the time, and it's since been raised to 68. So next slide, please, Gareth. I'm enjoying saying that. So Professor Ewart applied for an extension initially when he was 67, and he got one, and he was put into a 2-year fixed-term contract. So he vacated his old contract and was put on a different one. And at the end of the 2 years, he still wasn't ready to retire. He applied for a further extension, and he wasn't given it, and he was forced to retire. And we said both the placing of him in a fixed-term contract and his ultimate retirement were discriminatory, and that his ultimate retirement, forced retirement, was a dismissal, which was unfair. And we succeeded with both claims in the employment tribunal. Less relevant to this talk generally, but it's an interesting fact, I think. His unfair dismissal claim was successful, and unusually, he was reinstated. He was reinstated 3 years after his forced retirement, so when he was 72 at that stage. We think, unless someone on this call tells me otherwise, we think that makes him the oldest person ever to be reinstated in this jurisdiction. I stand to be corrected in the chat box. But it's an interesting feature, perhaps, of compulsory retirement schemes, that they are perhaps a fertile area for reinstatement orders if claimants are successful in establishing the dismissal was unfair or the policy was discriminatory, because their employment will have been ended usually on good terms without any concerns over performance. And so we were able to secure a reinstatement order. And of course, we all sometimes think in terms of unfair dismissal claims, the maximum exposure is 12 months compensation under the statutory cap. But of course, that's not right when you get a reinstatement order. And with the delays in the tribunal system at the moment, cases being heard so long after the event, this one was heard 3 years post compulsory retirement. He was entitled to 3 years back pay and was reinstated. So illustrating the risks to employers are fairly significant if they get this wrong. But the real issue is, of course, about discrimination. And the tribunal found he had been discriminated against and the treatment was not justified. So look in a little more detail at the reasons for that in the next slide. Our case, in a nutshell, I think my written submissions were about 70 pages, so I won't take you through all of them in the next 5 minutes. But in a nutshell, we had 2 big points, really. One was that this compulsory retirement policy was having only a very minimal, a trivial effect on the creation of vacancies. And everybody agreed, say everybody, the university agreed, that vacancy creation was really at the heart of compulsory, of achieving all of the aims. The aims I've taken you to could not be achieved without vacancies being created. And of course, that's what happens when you get rid of people by reason of forced retirement. And I would suggest that's likely to be the case in almost every one of these cases. The aims you can come up with to justify these schemes are going to depend upon the fact you're creating a vacancy and then what you do with it. So there are 2 steps, really. One is, are you creating vacancies, and if so, to what extent? And two is, what are you doing with those vacancies when they are created? And we said, really, this policy was only creating a trivial number of vacancies. And secondly, there was no evidence that those vacancies were being put to the purpose or being to the use of fulfilling the legitimate aims that the university relied upon and we accepted were legitimate. In other words, it just wasn't making a difference. And in relation to the first of those points, it's not really about the creation of vacancies. I mean, that's rather loose language, because of course, a vacancy will be created at some point. Nobody apart from Mum Ra, the ever living, lives forever. So when you die, a vacancy will be created, or when you choose to retire at a later point in time, the vacancy will be created. So this is really about speeding up vacancies. They're going to become available more quickly the younger the retirement age is set. So it's about the vacancy creation rate and what difference having a compulsory retirement policy makes to that rate. And what we really said was, look, if you look at the fact that many vacancies, actually more than 50% amongst the Oxford cohort of people this policy applied to, more than 50% of vacancies arose for other reasons, not retirement. Even within the retirement group, most people were choosing to retire early, not leaving because they were forced to. Of those that did make it to 67, a lot of those people were retiring voluntarily and not because they were forced. And then of those who did want to stay on, actually the evidence was they wouldn't have stayed on for that long, 2 to 3 years at most. So, and there was evidence for all of those things from documents which the university itself had produced, such as surveys of staff, statistical data about reasons for leaving, which they'd kept, the data from the pensions provider. So there was all kinds of evidence, which I would suggest would probably be available in other cases, where you could piece together the potential impact on the vacancy creation rate. And we did some statistics on that, some calculations, and came to the conclusion that it was only making a 2 to 4% difference, which we said was trivial. The university didn't do the same calculation. It attacked our calculation for various reasons, but it didn't do its own. And that proved to be quite important. It said it was too complicated and it was too difficult to do accurately. So that was our first big point. And the second big point was, well, even if you are creating more vacancies than that, you're not putting them to use in the way you say you are. And essentially, we had data where we were comparing what happened at Oxford to what happened at other universities and saying, well, actually, look, you're not increasing the number of women employees, you're not increasing the number of employees from ethnic minorities at any greater rate than all of those other universities who don't have compulsory retirement. You're recruiting people who are older from abroad rather than giving opportunities to people who are younger from Oxford. And so you're not really achieving the aims with the vacancies you do have. So in a nutshell, that was our case. The next slide will tell us, hopefully, what the tribunal made of it. And in short, it didn't really consider the second point because it said Oxford had failed at the first hurdle, really. It was not, or there was no evidence it was creating more it was making more of a difference than the 2 to 4% impact on vacancy creation that we posited. And given the burden is on a respondent to justify a discriminatory scheme, it had failed to do so. Sean Jones, QC, who was for the university, said that vacancies were the currency of achieving the legitimate aims. And so the tribunal essentially found there was just no currency, no money to spend on the legitimate aims because there was insufficient amounts of currency being generated. And so it didn't really need to consider the second point about whether or not it was achieving the aims, because when you took into account this was only a trivial amount of currency being generated, you had to set that against the severe discriminatory impact of the policy. And of course, telling people they have to leave employment because they're old is a severe discriminatory impact, and was found to be, even though at Oxford, employees could often stay on in an emeritus capacity, allowing them use of facilities, etc. But for Professor Ewart, that made little difference because he needed a team around him and a laboratory, which he didn't get as a retired emeritus professor. Professor Pitcher, on the other hand, in his case, was a Shakespearean scholar who didn't need much more than, a copy of Hamlet and his brain. So he was less significantly affected by a move to emeritus status than Professor Ewart was. And I think the two tribunals perhaps saw discriminatory impact through the lens of the facts they were looking at it, even though it's not about one person's impact, it's about group impact. But nevertheless, I think that affected the approach in the two cases. And so the tribunal dismissed the respondent's justification defense and its arguments that it was so obvious that it was creating vacancies, it barely required evidence, that the causative effect was too difficult to determine, and it was too early to tell, which were its three main points. The next slide, I think, Gareth, deals with Pitcher. And as I've said, that tribunal came to the opposite conclusion. This was heard before Ewart, and without the benefit of the same statistical evidence or argument. And the tribunal in that case, in a relatively short judgment on proportionality, although a long judgment overall, concluded the policy was justified. It was too early to tell, too hard for the respondent to prove that the aims were being achieved. There were too many confounding variables, and it was obvious enough that it was. So a completely different decision. And Professor Pitcher appealed because, as Sean Jones said, he had got Ewart envy, having seen the judgment in Ewart, which I don't think he liked very much. So what did the AT do? Well, next slide, please, Gareth. Thank you. I don't think any of us really anticipated it was likely to do this, because it would want to achieve a sensible, harmonized, consistent result. But what it said was both tribunals came to permissible conclusions. Different tribunals can come to different conclusions on proportionality, even though they're considering the same policy adopted by the same employer in respect of the same aims, and even where the evidence adduced is the same. Unless, of course, it's obvious or Cochrane obvious from the case Gareth talked about, that a proposition, it is having a particular effect is so obvious, then of course, if it's that obvious, it's likely to be perverse to reach a different conclusion. But absent those kind of cases, tribunals have a discretion to come to their a view about it, and that view, unless there's an error of law, is one it will be entitled to reach. And on the facts of this case, the impact on vacancy creation wasn't obvious. The AT agreed that. So this wasn't a Cochrane obvious case. That's the phrase used by the judge in Ewart. In any event, there were differences, as I've said, between the evidence and the submissions put in both cases. So both decisions ended up being upheld, and the tribunal approved or said that at least the reasoning in both was permissible. Where does that leave us then? I should say, because one specific ground of appeal related to extension procedures, and these are likely, I think, to be important in all policies of this nature. Sorry, next slide, please, Gareth. Thanks. So extension procedures are permissible. You don't have to have a blanket policy. There's a Court of Justice case of Fuchs and Landhessen, a German case where German prosecutors were allowed to stay on to complete a particular case they were working on. And that was found to be an extension procedure that didn't undermine the purpose of the policy. The EAT in Hewitt and Pitcher said the tribunal was entitled to find the extension procedure didn't substantially mitigate the effects of the policy. There are two issues really with extension procedures. One is they can undermine the whole purpose of the policy in the first place and therefore make them unjustified. But two is, on the other hand, they do have the potential to mitigate discriminatory impact. And of course, when you're conducting a balancing exercise, if discriminatory impact is reduced, then the prejudicial effect of the policy is less, and therefore justification ought to be easier. And what the EAT said was, dismissing the respondents, the university's submission, Fuchs, they said the tribunal had got it all wrong because Fuchs said that this type of extension scheme was permissible and mitigated the discriminatory impact, and they hadn't really taken that into account. And the AT said, no, that's not right. Fuchs was about whether an extension scheme undermined the policy. But here, the respondents, the university's extension scheme, it wasn't about undermining the policy. It was about not really mitigating its discriminatory impact. And that was because essentially it focused on the respondents' interests. As I said earlier, it weighed the wrong things in the balance. And really what was going on here is the university was using the extension procedure as a way of picking and choosing which people it wanted to stay. And that wasn't permissible. And Lady Smith, who in an internal appeal court case at Oxford, because Oxford, unlike I imagine most employers, has retired Court of Appeal and High Court judges hearing appeals in an appeals court, not something your average high street employer has. Lady Smith, in a case involving a Professor Gallagher, thought the type of extension procedure Oxford had could never be justified, and basically meant the policy was automatically discriminatory. So what can we take from these decisions? In summary, next slide, please, Gareth. The lessons to be learned, really, conclusions are, it really does, these two inconsistent decisions emphasize the importance of first instance decisions and the limited role that an EAT, or the AET, has in overturning findings of a tribunal on proportionality. Of course, it means there's a problem with legal certainty because an employer cannot assume success in one case will mean necessarily success in another, although ordinarily cases are likely to be persuasive. And one would think employers might be more sensible in having connected challenges heard at the same time so as to avoid that possibility and increase the persuasiveness of the decision. It's not safe to assume compulsory retirement or the effects of compulsory retirement are obvious. At least for large employers, the position I accept may be different for smaller employers. And extension procedures can be a double-edged sword. They can mitigate the effect of the harsh effects of the compulsory retirement policy, but they can also undermine the policy itself. I think the lessons then to be learned from Hewitt for others are, particularly large employers need to think very carefully about the evidence on they can adduce about the effect of the policy on the vacancy creation rate. Employers are not required to prove the impossible, but evidence of legitimate aims being achieved or being likely to be achieved is probably going to be necessary. And that means statistical evidence, internal from what's going on within the organization, and external, what, if possible, can you compare to other similar industry or organizations who don't have such schemes? Surveys of staff, existing and retired, case studies within departments, or where that's not possible and a policy is being introduced, reasoned projections about what it's going to do. All of that really was lacking, we said, in Oxford. And well, despite the presence of many statistics, they hadn't really got to grips with the key issues. and the tribunal agreed with that. And extension procedures need to be designed very carefully and shouldn't be a proxy for employer selection of employees. And last point, really, policies don't have to be applied to everybody. If they'd applied this policy just to statutory professors who tended to be appointed at a later times, tended to stay on later, tended to be pretty much all men, tended to be all white, it would have probably been much easier to justify. But because they applied it to so many, it diluted the justification defense. So I think those who are designing such schemes really need to think, does this need to apply to everyone, or can we, in fact, target it more in a more focused way where it's really needed? So those, I think, are the lessons to be learned from Hewitt. And then I think I'm just going to hand back to Gareth to quickly run through this 10-point checklist.
Yeah, so it's 4 minutes to 2, and if you are still on the call, and there's a number of you, which I'm grateful for, these are not going to be new. The idea behind them is they are a run through of what we've tried to cover in terms of justifying what might be a ostensibly discriminatory policy, such as a compulsory retirement policy. The first question is, what are the aims of the policy? Are they legitimate social policy aims? That takes us back to the discussion in Selden. There was an age concern case as well, and the Heskett, comparing that with the Heskett line of cases for indirect discrimination. What are the aims of the actual policy? Second, are the aims legitimate for this particular employer? So that then focuses on, well, is this particular employer benefiting from the aim that is being pursued? Is there something about the particular nature of the business that means that this particular policy or retirement policy is legitimate? So setting aside the social objective policies that have to be established with direct discrimination, does it apply actually on the ground for this particular business? The third and fourth, taking these together, can the employer produce evidence of the impact of the policy on, for instance, vacancy creation? That takes us back to what Andy was talking about in terms of the what was described as the sort of the core, the rate of vacancy creation being the core issue, and all of the other aims being related to that. Can the employer produce evidence of that? And can the employer produce evidence of the achievement of those aims? And that's where a lot of the work will be done by you as lawyers with your clients, whether you're for claimants or respondents. As Andy described, it was with the assistance of Professor Hewitt that the statistical evidence was produced to show that there was a trivial effect of this particular policy in the Hewitt case. Is there evidence? Can you establish evidence that supports, or if the claimant undermines those aims? 5. It may be, for instance, as Andy talked about, that the policy, and in the Pitcher case, for instance, what was accepted in the Pitcher case is that there wasn't sufficient evidence, perhaps because of the age in which the age for which the policy has been in place, the time it's been in place for. It's not going to the statistics are not going to show the effect of the policy because it just hasn't had time to have that effect. That may be accepted, that may be right, but is there an obvious effect of the particular policy? The Cochrane obvious description of, for instance, you get your long-term incentive plan unvested awards at 55 but not before. That's going to incentivize people to stay to 55, and that would be established as something that was Cochrane obvious and not needing further evidence. 6 and 7, quantitative discriminatory impact, qualitative discriminatory impact. What are the numbers of this? Goes back to the balancing exercise. What the tribunal has to be satisfied with is that the discriminatory effects of the treatment can be justified. How many people are being affected by this, and to what extent are they being affected? Is this having such an impact on somebody's, for instance, career, that the extent to which the policy applies, the number of people it applies to, what the consequences of its application are to the employee's contract of employment, all of that has to be borne into account in undertaking this balancing exercise. So that's the thought process 6 and 7 that you will want to go through when examining the impact of any particular compulsory retirement policy. 8, Andy touched upon this most at the end of sort of the Fuchs line of authorities. well, are there derogations or exceptions? Is there a liberal extension to the policy? Will this actually undermine or benefit the aim? It can be looked at in different ways. It can be framed as to mitigate the effects of the policy, but without in fact undermining the aims. If they can, that's going to help in justifying it. If it can't, it's not. So the derogations and exceptions to the policy are an important aspect to consider. 9, is the policy reasonably necessary, and would other less discriminatory measures suffice to achieve the aims? That goes back to the question again of ultimately proportionate effect, and finally, is there a regular review of the measures and the effects? If the employer is not doing that and the policy is stale, if we could put it that way, that's going to harm an employer's ability to justify it in an employment tribunal that the application, much more recently to an employee, is justified. So that should be something of a helpful practical checklist when considering compulsory retirement policies. We are over the hour. I see in the chat box that it's only Andy, which is, yeah, okay, that's fine. Andy said if you want to ask any questions, then we're happy to stay on past 2, which is right. There are no questions in the chat box. We have finished the talk now. If anybody does want to ask a question, we'll stay on for 30 seconds. If you want to email us, as I said at the start, you're more than welcome to. Andy, is there anything else that you want to add, just as we're letting people ask questions if they want to?
No, not from my perspective. Just thanks all for attending. I hope to see you soon.
Yeah, thanks for everybody. I don't think there are questions, so thank you again. Bye now.